Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's lockdown edition question is, I need to liquidate my company, but the landlord has taken a personal guarantee, which means if I liquidate, he's going to come after my family home. What should I do? So the answer to this question is actually quite complex because it's a very tricky situation to be in, and unfortunately a situation that many people, including hospitality businesses, restaurants, retailers, anyone with commercial premises is finding themselves in right now. So there's a few steps to this. Firstly, if the company needs to go into liquidation because it isn't sustainable, the business isn't making profits, there isn't any more sensible bank lending or financing or investment to be put into this company, it just doesn't make financial sense anymore, then the company should be liquidated. But before it's liquidated, we need to work through what the flow-on consequences are. So when someone signs a personal guarantee, typically the directors of a company, what they're saying is that if the company doesn't pay this debt, I personally will pay this debt. Now, a lot of people don't realize what they're signing at the time they're signing it, especially when they're signing commercial lease. But this clause can also apply on supplier accounts and many other places, financing agreements, many other places. So now what happens is that person's personal assets, including any family home in their name, any other real estate, any other assets really, are put at risk because a landlord who has a personal guarantee from a director can say, okay, the company's gone into liquidation, it can't pay, it's got no assets, I'm not getting any money out of that source. So I can now turn to you as the individual, the director, to get payment. Now, this puts people in a very difficult situation because they don't want to liquidate to trigger that personal guarantee, but they need to liquidate because that thing isn't making money anymore and it just cannot continue to trade, and the director doesn't want to get done for insolvent trading either. So now it comes to a risk management type approach. What assets does that director who signed the personal guarantee have in their name? Now, they might have a family home, that's quite common. If they're well structured, they may not have any assets in their name at all. Now, it becomes a bit of a balancing act here, because if they let the lease continue to run and debts in the company continue to accumulate, especially if they're debts that they're personally guaranteed, the hole they personally find themselves in can actually get larger. So a lot of people will approach me and say, I can't believe the situation I found myself in. I didn't expect to be here. It just cannot get any worse. And the unfortunate answer to that is it actually can. The hole can get bigger, the debts can get larger, and that person will generally get more stressed. So it's generally better to stem the bleed. But that means having a look at what assets are at risk in that person's name. If there's no assets, then it might not be a problem at all. That person might need to declare bankruptcy if the landlord chases payment all the way into bankruptcy. Having said that, just because there's a personal guarantee doesn't mean that the landlord or whoever holds the personal guarantee will pursue that individual under it. It depends what the history of the discussion has been and what the landlord or that creditor's temperament is. Now, the ideal situation is to be able to settle with the landlord or whoever holds that personal guarantee and say, look, I can't pay you all the back paid rent and all the future rent due under this contract, plus the cost of making good the premises or stripping it back to a bare concrete block, but I can pay you this. This is best available. And if you make me bankrupt, this is the best you'll get from my bankrupt estate anyway. So it becomes a negotiation. And then it depends on the temperament of the landlord and what they're willing to accept or not accept at the time. Now, if they're willing to accept a settlement, and it's a settlement you're either able to pay now or over time, then you've quarantined that risk. Now, what happens if they don't accept a settlement? So this is when it becomes a possibility that that director may need to go into bankruptcy. Now, the standard starting position in bankruptcy is that things like real estate, so family homes, investment property, vacant land, commercial premises owned by that individual, do get lost to the bankrupt estate in return for all that individual's debts being wiped out. Now, in terms of how the bankruptcy trustee may deal with any real estate, including any family home, say our approach, and an approach that you will find other bankruptcy trustees have as well, maybe to see if that real estate can be sold to a family member or friend. And sometimes the person who's bankrupt and their family can remain living in it. So it doesn't feel like much of a change, even though there's a legal change happening there. Now, if a bankruptcy trustee is selling it to a friend or family member, then money will need to change hands. So there will need to be some sort of payment for the bankrupt's equity interest in that property. Now, it all gets a bit technical from here, but if you think you're in this situation and want to explore if you can save your family home or save it in that way of perhaps a friend or family member buying it, what does that mean? What criteria needs to be fulfilled in order for that to happen? Just reach out, because it's best explained usually in people's individual circumstances, where we can look at some numbers and see if the numbers could work out, and work through what would happen if this person had to go bankrupt, and what would all the flow and consequences be, and how severe those would be for that person and for that family.